Good morning, viewers. Thank you very much. Welcome to Punchline Africa Television, broadcasting from the Political Command Center in Africa. Good morning. Thank you very much. I am Dr. David Masanga, presenting this program as a host, and my co-host in Nairobi, Kenya, is none other than Miriam Ogutu. Good morning, Miriam Ogutu.
Doc, a very good morning to you, and good morning, good afternoon, good evening to our viewers.
Thank you very much across the continent of Africa. Thank you very much, all our viewers, for the patronage that you have kept for the last 6 to 7 years. We are approaching 7 years since we came online. Thank you very much for giving us that patronage. And good morning, good afternoon, good evening, wherever you are in the continent, outside the continent, in the universe called Earth. Thank you very much. Today's show is none other than a very great show for the people of Africa, a great show that touches something that is very, very important, and that has actually been part and parcel of the politics of this country called Kenya for the last 10 years or so, or 12 years. It has not gone away. For us, some of us are countries across the continent of Africa, like my country where I come from. This has been there since 2005, when the first warrants of arrest were issued against the LRA commanders. The ICC did that in 2005, and we are the first country on the African continent to be issued with warrants of arrest. So for those who think maybe it started in your place or in Kenya, forget it. It started in Uganda. The first cases of International Criminal Court arrived from Uganda, and the 5 commanders, one has been captured, some died, others are on the run. Thank you very much. These cases also came to Kenya, but it is not Kenya on Africa that has suffered the wounds and the wounds of ICC. Several countries on the African continent, name them, from Libya, Sudan, Congo, Democratic Republic of Congo, South Africa was taken to the ICC because it did not comply with the arrest warrants that were issued. Uganda was taken to the ICC. Kenya was taken to the ICC. Ivory Coast was taken to the ICC. Central African Republic was taken to the ICC. Those are some of the countries that I know very well. We have Sierra Leone, went to the Sierra Leonean court for justice, which is tribunal, that was held also in The Hague. Yugoslavia, Liberia. Those are countries in Africa that have seen, and the only country in Africa that has so many cases, several cases, piled up, is none other than Democratic Republic of Congo. It has like about 6 cases, situations. In Burundi, it was also taken to the International Criminal Court, until Burundi is the only country on the African continent that has deserted, that has run away from the International Criminal Court. The rest of the African countries have been paying lip service, and they have not utilized Article 127 of the Rome Statute that talks about departure. If the marriage is not working, leave, run, and go away. Most of these countries still suffer difficulties, and the more countries are being taken to the court across the globe. You find countries like Russia now is under investigations. Other countries are also under investigations. But why is it that it is only Africa and on the African continent that most of the cases were concentrated here? That is the question for today, which we want to start answering in a few minutes. But before we do that, let's refresh our minds with one of the cases that took place in Africa that I took part in, and let's see what the video says. Video.
All right, they're just about to get it on. So once it's ready, they will signal. So perhaps we just continue with the introduction of the speaker today. Yes.
So it is sad that today, after a long 12 good years, Kenya has still remains in the International Criminal Court corridors. Kenya is still a country that is besieged. Day in, day out, this court comes back. There's still something attached to it. I have said myself, I've told my inner thoughts. Why do African countries want to stick to the International Criminal Court? Why should a normal country remain there when it has got its own courts that can try people of crimes that are triable in those countries? I have not found answers, but I'm told that the tape is ready. Let's go to it and see why Africa still remains in the hands of ICC. Those listening and watching me from The Hague, and those watching me from Khartoum, I want to thank you. First, I want to pay my respect to the government of Republic of Sudan. I want to pay my respect to my friends, the generals, the two of them, especially General Daglo. General Daglo, my friend, when I knew you, you were a Lieutenant Colonel. I want to make sure that you don't fall into an international trap that will bring us to 2 tears more than joy. I know very well very many people in Sudan would like to make, and the world would like to take a retributive route against President al-Bashir. Yes, crimes were committed, yes. The Sudanese stood up and went to the streets, demanded freedom. Bashir surrendered the power. Generals came, swept him out of power. The most important thing today, as we speak, there are so many militias gathering their momentum in Sudan itself. Is it the right time for Sudan, and I'm addressing the Sudanese government directly, especially my friend General Daglo? Remember, the Janjaweed were named as one of the factors that actually brought the chaos in Darfur. It will not be long before the same court that is smiling at you, before the same chief prosecutor, Karim Khan, who is smiling at you, living in Carthage Hotel, in rooms 2040 and 2062, occupying the whole floor. It is not going to be long before he turns on you. General Daglo, I'm addressing you as an African. We're almost the same age. We have been together, we know each other from 1990s. I've been a visitor to Khartoum. I have seen so many things across Africa. General Daglo and General Hamed, I just tell you, the same Karim Khan smiling, whom you are welcoming tomorrow, will call yours. You open up a Pandora box by delivering your former head of state, instead of putting him on trial. The Sudanese justice system is good enough to put somebody on trial. Sudan is a country where the cradle of justice began from. Sudan can try its nation. Sudanese can be tried in Khartoum so that the people of Darfur can get better justice, can see the fruits of why justice system is there. Dear journalists, my brothers, comrades, the same ICC that you see that faked this case, the same ICC that airlifted the witnesses, procured the witnesses, like they have done in several African cases, will one day come back for you. You have not destroyed the Janjaweed. It is there. It is the militia mentioned. Who are the commanders? Who are the participants? Think twice before you hand over General al-Bashir. I have come at this hour to alert you as a brother who has faced International Criminal Court from the first case in Uganda. I therefore speak with authority. I therefore stand with authority. There is nobody out in south of the Sahara who will speak with authority on the question of ICC. There is only one man, and this is the man, Dr. David Matang. I have opposed them. I will oppose them. I will continue to deny them any chance of taking any African to the Montego Bay of Europe. I will deny them any chance of going out to slaughter Africans, to put them in a keg, as if we have no system in Africa that can try us. A court in Khartoum is better than a court in The Hague. Why do I say so? The court in The Hague has no assessor. The court in The Hague has no interpreter. The interpreters are either coached by the same court. The court in the Hague, the prosecutor is the hunter. The hunted continues to prosecute, to investigate, lays the case in the court, seeks a conviction. That is one person. The court in Khartoum allows the police to investigate, brings the culprit evidence against the suspect. But the court in The Hague allows the chief prosecutor to take over all these functions of justice. The people of Sudan should think twice. Yes, I know there are crimes that were committed. Yes, I know many people died. But let's look at Darfur today. When we walked in Darfur, I and the Thabo Mbeki, flying in the planes, dropping in Khartoum and going to Darfur, sitting in Nairobi, in Johannesburg, in Khartoum, in Carthage Hotel, making reports to make Darfur better, to find a long-lasting. I want to take this opportunity to thank President Thabo Mbeki, the African Union envoy on Darfur. I want to thank President, my good friend, Professor Gambari, the head of the political department of the forces that were put there by UNIME, forces that were in Darfur. Professor Ngambari, wherever you are, remember what we discussed, what we said. This is the first place in the history of Africa, Professor Ngambari, for a country to get freedom. The people of Darfur returned to normality. Darfur itself had returned. There was forgiveness. There was a reconciliation. There was a redemption strategy. The case of Darfur was killed from day one. How was it destroyed from day one? I want my panel to listen to me carefully on this one. When you arrest suspects in all Ocampo's cases on African continent, and I want to speak with authority, because there is nobody who is going to say I am wrong. Look at the case of Pierre Bemba. In the Congo Central African case, Mr. Pierre Bemba was indicted and Mr. Bozize was not indicted. My panel, listeners, viewers across the world, the case of Thomas Lubanga. Mr. Thomas Lubanga was indicted. None of the commanders of the Congolese army were indicted. My viewers, again, the case of Thomas Lubanga should have taken Mr. Kabila, because Mr. Kabila was the final responsible for international law. The baton sticks with the commander-in-chief, who was the commander-in-chief of the Congolese army that was fighting Thomas Lubanga. The case of Ouattara of Babugo, Mr. Ocampo should have taken both Ouattara and Babugo. Mr. Ocampo came and took Babugo and left Ouattara. Mr. Ocampo came, went ahead to indict Babugo's ministers, Babugo's relatives, including the wife. The case of Libya, Mr. Ocampo indicted Muammar Gaddafi, Saidi Gaddafi, and the children, and they left the commanders, the terrorists who occupy Libya today, were left out. Africans don't want to listen. They don't want to know. But these things are going to come there tomorrow. For those who don't want to know, it's your problem. Didn't I tell you Ethiopia will collapse? It's your problem. Didn't I tell you? Most of you were shouting at me. Some of these Kenyans who have never gone to school, some of them, idiots coming to insult me. Some have gone to school. Those who have gone to school, not saying Kenyans have not gone to school. They have gone to school. But some idiots paid 50 shillings to insult the people. They don't listen. The case of Gaddafi, Mr. Ocampo indicted one side, left the other side. Let's come to the case of Kenya. Thank you very much, Miriam, and thank you very much, Gladwell. Our viewers, this is a very exciting moment, and I believe everybody in Kenya would like to know what is taking place. The Kenyan case currently under Article 70. What is Article 70 then? Article 70 is an article that talks about perjury, obstruction of justice, tampering with witnesses, prohibiting witnesses from taking part in the trial. When you commit a crime against Article 70, you are committing a crime against the court. You are not committing a crime as a state partner or a state against ICC. It is the court. Therefore, the case is already in the court, but you are stopping witnesses from going to that court. So Article 70 of the Roma Statute is one of those articles that brings people to trial. As you are aware, Mr. Gicheru and Miriam will give us more details. Then I can now do the analysis, which way to go. Back to you, Miriam, and good morning, Africa. Good morning, Gladwell Kirapo in Nairobi, Kenya. Thank you.
Thank you so much there, Doug. Now, the Kenyan lawyer Paul Gicheru will not put up a defense against the evidence presented by the prosecution on charges of bribing witnesses in the war crimes trial against Deputy President William Ruto at the International Criminal Court, that is the ICC. Mr. Gicheru's lawyer, Mr. Michael Canavas, yesterday informed the ICC in a one-sentence letter that he will not be presenting a case against the evidence adduced by the Office of the Prosecutor. Mr. Canavas is expected to make arguments either oral or written, poking holes in the prosecution's evidence and portraying it as incredible and insufficient to secure a conviction. During the trial that started on February 15th and ended on March 24th, the prosecutors tabled evidence of 7 witnesses who testified on the alleged involvement of Mr. Gicheru in offences against the administration of justice. The prosecution claimed that he played a role in a well-planned scheme to frustrate the trial of Dr. Ruto. It is alleged that he offered in excess of 20 million Kenya shillings bribes to 8 witnesses to recant their evidence and withdraw. As prosecution witnesses, he faced 8 criminal counts involving witness interference, bribery, intimidation, and Mr. Gicheru has denied all charges. The new twist in the case means that judges will only use the evidence and testimony of witnesses called to the stand. Back to you, Doc.
Thank you. Thank you very much, Miriam. The very fact that Mr. Gicheru now keeps quiet, there are 2 things that can come out of this trial. And I want to be candid and tell you it is very difficult. First, I want to tell you that it is very difficult to defeat Article 70. They only need probative value, what we call probative value of the evidence. Were you near? Did you talk to one of them? Is there proof that money was transferred? Where did the money come from? If you didn't have that money on account, did you talk to that person? A mere proof that that was the case is not beyond reasonable doubt on Article 70. The other articles, you need reasonable doubt. Did you kill? But I'm telling you, from what you can see, the case of Bemba versus the chief prosecutor and the witnesses, the lawyer of Bemba used to go and look for witnesses, talk to them, until some of the witnesses recorded him and came back and told them, he has threatened us, he talked to us, he sent us money. And the amount of money in Bemba's case were about $200, $300. It's not the amount of money that we are talking about in the Gicheru case. So, all in all, Article 70, tampering of witnesses, is a very serious crime against the court. It's not the state against you. It is the court against an individual. And that individual in this instance is Paul Gicheru. He is there. He should have come out with his defense and said, I don't know these people. The very fact that he has said he is not going to give any evidence is an assumption that he is guilty already. Therefore, the judge doesn't need to look anywhere else. Even if the lawyer talks, because they will know the lawyer has to mitigate, even at times lie just as Karim was lying, that there was no evidence interfered with. Karim himself, the chief prosecutor, is a liar, because at that time he lied. It is, if this case is proved, Miriam, it is now going to be Karim to say, did you know this or you did not know this? What could come out in May? And I want to be candid to Kenyans. I hope you are, Fred is taking note of this. I hope so. Candid to Kenyans, that this case could be, after it has been summarized in next week, the court will go back to keep quiet, study the evidence. By the end of the month, next month, there will be determination. The determination will change the course of the politics and the course of the journey that we have been talking about. Because the lawyers of Mr. Gicheru did not manage to shrug themselves off from the evidence of William Ruto. William Ruto's evidence was brought, and actually he had tested fresh. So you can't say I'm not part of this trial. Whoever is advising William Ruto that he's not part of the trial, in fact, if your evidence which was against you is part of the trial, then you're already part of the trial. So he's also equally on trial. Another point that I would want the audience and other people worldwide who don't know more about ICC is the question of, you have been mentioned 800 times in court. The judge would like to know who you are. Who is this big man they call big man? If the case comes to a conclusion, the judge could recommend that those who are mentioned as accomplices must appear, must also be, action should be taken in the final determination. Therefore, the prosecution could decide that since, and go back to Chamber 2 and ask for more warrants of arrest, unsealed or sealed, whatever you call them, they will come. That's the possibility, that there are more people out there who took part in a scheme together with William, with Paul Gicheru. So this case then now sealed upon that. You can't say I was not there. You cannot be a managing director of a company where money is being drawn, and you are the owner of the company, and then say you didn't know that money was being drawn. Then what was your managing director telling you that the money went where? Another strand is the records of telephone conversation voices. The ICC has picked Safaricom discussions. It has taken them between Gicheru and William Ruto and others. So the judge will listen to these telephone conversations. What were they talking about? Above all, I don't think Gicheru was talking encouraging, because Gicheru was talking either in Swahili or was talking in English. Because most of the people accused with Gicheru, none of them talks the language that Gicheru would understand. Therefore, we have a problem there. If those records prove that, yes, Ruto was making communication with Mr. Gicheru in the direction that they should go and tamper with the witnesses under Article 70, that is a sealed case. It is not dead end, it is an open end. The prosecution could decide that now that we have got Mr. Gicheru, can we now also bring Mr. Ruto? Do we open Ruto's case because of Mr. Gicheru? It depends on the evidence, on how far that evidence is going to affect and implicate, and who were the key witnesses who have come out under the Gicheru trial, who could actually be very beneficial to the new evidence. Remember, the 7 witnesses are the ones who recanted, and therefore the trial of Ruto could not take off because they had recanted, Miriam. And therefore, when you look at that, that presents another dilemma. So another strand, school of thought number 4, is how blessed are we today that there cannot be interference. The outcome, there could be collateral damage. One of the collateral damages would be Karim could resign. Because if the case comes back, it is going to come back in the main court. And because of interest, he could be told step aside. Pressure would mount by international donors and agencies to say, no, you are part of the defense team of that case. Therefore, you cannot stay and then monitor and then pay, make payments, authorize payments, because the chief prosecutor at the moment controls the budget of the International Criminal Court. So this could interfere with the cases. Having said that, though, what are the implications of these cases coming at this time? If there are warrants to be issued next month, as a result of Gicheru's saying, the way I see it, Miriam, Gicheru seemed to be going to say, tell his lawyer, I am guilty. That's why he has said, you don't know what submission the lawyer will say. The lawyer would come and say, my client says he's guilty of the offenses, and therefore I leave the court to make a decision so that we don't waste much time of the court. So Gicheru could become a witness who will now identify the others who gave them the money. You see where we are heading now. If that happens, then it has effect both nationally, locally, regionally, and on anything that Kenya does between now and that time. So in a nutshell, that's where we are. That's where we are. The road, the end of the road for Gicheru is here. Miriam, is here, the end. You know, when the road is wide, it goes on being narrow, it narrowed until Gicheru himself cannot stand. Gladwell and Miriam and the listeners and the viewers and say, I protest. I protest. I never saw those witnesses. No. He has decided either to tell the lawyer to tell the court. So we wait and see what the lawyer in the few days will file. We shall pick it first hand. And I always pick all that information first hand. And I will bring it to the audience in Africa. Any questions before we do the summary? Gladwell, or yourself, Miriam.
No, I wanted to say that you've explained, so well the background of the case that Kenya has, of course, tying in with others that you've seen across the continent. So perhaps if at all Gladwell has something she wants to ask or add to the conversation, then Gladwell, you're welcome.
No, actually, I don't have any. I've explained that in a better way. Yeah.
Okay. If there is nothing, there is another strand. That is strand number 1. Strand number 2. This goes further to warn Kenya, because our topic is the ICC returns to haunt Kenya again. What lessons did we learn from the first? What lessons do we learn from this? Time and time again, I have told my Kenyan people, the organization called International Criminal Court is really criminal. It is not the it is a criminal. There are criminals inside there themselves. And I want to be very honest. I am not a friend of ICC at all. I don't like them because they are criminals. They hide there. They sit in a lobby and make decisions. The Bashir case, the Saif Gaddafi case, the Babuko case, the Bemba case, all of these, the Uganda case, all of these are all criminals themselves inside there. Because when you look at all these cases, why did Babuko spend all that time in jail and then you release him? Why? It was his being in jail was a cooling point for the French to rearrange Ivory Coast. After they had rearranged Ivory Coast, they gave a signal that released him to go. Why was Bemba in court? Spend all that time, and then you say there is no case to answer. You go home. It was to cool a cooling period for Kabila, who had given them concessions for mines and minerals and gold and diamonds, so that Bemba can stay out. If you can look at Bashir's case was just a case of ideological differences between the Christians and the Muslims. It has nothing as basic. Yes, people died in Darfur. But when you look at the bottom line, why Bashir was pursued, and then the Jema group was not pursued, vigorously like they were pursuing the Jema, the Bashir side, the generals in Bashir's government whom they claim alleged they killed people. You can say it was purely. Look at the organizations that were paying Ocampo to come and fix Bashir. Look at the way the witnesses were airlifted to Chad in Jamena and Cairo in Egypt and Djibouti, where they made statements not on the scene, but they made statements outside the country under the influence of the International Criminal Court criminals. Why do I call? Because when you are an investigator, Miriam, you come, people have died, you pick certificates. There are three categories of our identification on planet Earth. If you don't have one of them, you can be identified with the other because of the other one. The first one is birth certificate. The second one is marriage certificate. And the third one is death certificate. If you ask Ocampo today, did he collect the death certificates of the people who died in the Rift Valley? There is not even a single one attached to their death. So was this court set to fail? Was it set to fail? You tell me. Is that a court you can go to? The last strand that I would like to come and advise Kenya. It is in the future, whichever happens, if I'm not here, wherever I will be, if God determines my destiny, I don't determine my destiny. Try to get Ocampo, try to get work list, work envelope, work commission of inquiry. Kibaki has gone. Nobody handed over Kibaki the envelope, but Kibaki will ask wherever he is, when they meet with Kofi Annan, what happened to the envelope? Who carried the envelope? The commission was done by taxpayers' money in Kenya. But the Kofi Annan ran away, stole the envelope, went, and the man who handed it over is still walking tall here, justice working. You have even given him a full court as if he did nothing wrong. That's the type of impunity that, Miriam, you have been talking about for a long time. It is still here. We can talk about the governance, but here, look at Work envelope. Work himself abrogated the same terms of reference of the committee and delivered the envelope to an outside body that was not supposed to be part and parcel of the government of the Republic of Kenya. So Kenya needs to address that issue, remove that envelope, expand it from its books for people who have been either associated or were there, not in the future, for them not to be punished. I submit, therefore, Article 127 of the Roma Statute is very clear. It talks about if the marriage is not very good, if there are quarrels, you are not understanding each other with your wife, you continue fighting in every day. Maybe one of you kills the other for nothing. Why don't you pack and ship and go? And again have a cooling period, and therefore maybe in the future you can think of returning to the house and say, Mom, I was sorry. The ICC relationship with Africa looks very slippery and very awkward because ICC is full of criminals. It's not full of people working for the interests of Africa. There are people who work against the interests of Africa. Because there are so many crimes that have been committed in the Philippines. You can't bring the president on trial. But in Africa, you have to bring the president on trial. Is it the court that we want? Time has come for Kenya to rethink and think fast. Does it need to stay in this organization where diplomats sit down and choose? Diplomats sit down and choose who should be the prosecutor. Not on merit, but according to the wavelength, the height, the color, the origin of the country where they come from. Is this the court? I submit it is not the court that Africa should be subjected in. Thank you.
And we thank you for watching. Bye-bye for now.
Way back in 1998, the late Secretary General of the United Nations by name Kofi Annan thought of an idea, brought an idea of saying the only way to bring world order where crimes committed that are not punishable in local courts, local countries, regional courts could be taken to an international crimes court. The Rome Statute and Rome Treaty of 1998 July was an offspring of already cooked DSGE intelligence system mechanism to keep Africa under check. Up to date, the French government pays 70% of the salaries of the International Criminal Court, from the porter to the judge, to the prosecutor, and the rest of the other people. This was a project of Kofi Annan and the Kofi Annan Foundation, followed by George Soros as an accomplice of Kofi Annan, brought in by Luis Moreno Campo and the entire system of the West, some countries in the West, to keep check on African countries that did not agree with the policies of the French and to their policies of Western culture. The International Criminal Court Chief Prosecutor Luis Moreno Campo agreed in all this that yes, he has been picking money, extra monies, and we followed the story together with my group in France, powerful investigators in France who worked together with me. And we found out that, truly speaking, Rui Moreno Campo, Fernandez Gumedi, the former judge, the president of the International Criminal Court, laundered money, some coming from American banks themselves. This evidence was put in the ICC. In the case of Bashir versus the chief prosecutor, I filed an application, which I still have, and which I'm going to publicize again, so that people can know that I was right. I've been vindicated, because the American friends now have found that my credibility is real, that I was right when I stood up to say this court is corrupt. This court launders money, $17 million of United States money, laundered through Bahamas, through New York banks, back to Ocampo's personal assistant, by then called Fernandez Gumedi Silvia, who later on rose to the ranks of becoming the president of International Criminal Court. It has taken us time, energy, effort, resources to investigate the corruption scandal that have rocked the International Criminal Court. Why should African countries continue to be in the ICC, yet even the superpowers like America are saying no, we have enough courts to try our own people? Viewers, it has taken Americans over 20 years to listen to our voices when we told Reinberger in Nairobi that this court is a corrupt court.
Today, on the eve of September the 11th, I want to deliver a clear and unambiguous message on behalf of the President of the United States. The United States will use any means necessary to protect our citizens and those of our allies from unjust prosecution by this illegitimate court. We will not cooperate with the ICC. We will provide no assistance to the ICC, and we certainly will not join the ICC. We will let the ICC die on its own. After all, for all intents and purposes, the ICC is already dead to us.
A case of the Kenyan people. These cases in Kenya, the chief prosecutor called Fatou Bensouda put serious statements at the end of the cases, discharge and termination. In legal language, these cases pose a very serious threat in the future. What the people of Kenya can do, and they should do, is today to wrap up the work envelope. Because until this envelope is sealed, thrown in Indian Ocean, the chief prosecutor in the future will come and look for that envelope, use it to incriminate people again. It brings me back to the situation. America is sealing its journey out of the ICC. Why do you wait? Why don't you take this opportunity to seal your journeys out of the ICC? America is quitting, warning that it cannot no longer be a party to such an obnoxious court, a court that has no powers, that talks from this side and vomits from the other side, a court that cuts and pastes evidence, a court that buys witnesses, a court that incites incentives, gives incentives to witnesses of a passport and a relocation, then you tell lies about people. A court that sentences you as per the words there. Why should you leave a country that has a jury that checks on what the judges would do, the excesses of judges, and go to a country, a court that has no jury? Time has come for Africa to think. Do we need this court? Does Africa need this court?